continuous violence against family.
Yes,
and
Judge.
now we have an assault case. I don't understand why I should follow this plea.
I just want to say I'm sorry for my actions.
I'm not going to follow this plea bargaining agreement. And we're in felony court for alcohol use, right? And you are a person who should not be around your grandchildren or your children because you don't have control of your addictions. You're using opiates. You need help.
Today's chaos stars an entitled girl squaring off against Judge Boyd, and trust me, it gets messy fast. She's in court for continuous violence against family and an assault case, but suddenly she's on her best innocent act like she's auditioning for a role in a soap opera. The problem? Boyd's not buying it for a single second. Watching her fake remorse is like watching a kid hide broccoli under smashed potatoes. You see right through it. Judges like Boyd hear these same performances daily, and the act usually collapses under the simplest cross-check. The real tension here isn't her fake tears, it's whether the judge lets her keep dodging accountability. Do you think Boyd should show her mercy or shut it down completely? Let's go ahead and dive in.
R9045W and 2022 CR 10906W, State of Texas versus Adriana Harrison. Can I have parties announced for the record for the state?
Anna Ochoa Nelson.
Danny Callahan, defense.
And are you Miss Adriana Harrison?
Yes, ma'am.
Have both parties received the PSI report, state
Yes, Your Honor.
defense? And also the DDRF MIC report, state and defense?
Yes.
Yes, Your Honor.
All right. Are there any objections to the PSI report, state?
No.
Defense?
No, Your Honor.
Any objections to the DDRF MIC report, state?
No.
Defense?
No, Your Honor.
Any witnesses, state?
No, Judge.
Defense?
Any what?
Witnesses?
No, Your Honor. May I amplify regarding the PSI? There are two programs that she has successfully completed. One is recorded in the PSI child protector. The other is aggression, anger management, Your Honor.
All right. So in regards to this case, the state is recommending deferred adjudication.
Apparently we are, Judge.
So I don't understand.
Just for completeness.
No. I mean, why should I go along with the deferred adjudication? And the reason why I'm saying that is because one, I'm not the person who took this plea, but she's on deferred adjudication for continuous violence against family.
Yes,
and
Judge.
now we have an assault case, and she had a previous motion to revoke, and that was for a violent offense as well. I don't understand why I should follow this plea. And I'm keeping an open mind about it. I'm trying to figure out.
Yep. Yeah.
I could understand if there were mental health issues or something else that was going on. So if y'all want to address that.
Judge, this offer and plea was entered by a different assistant district attorney. At this point, I'm bound to honor that. I don't know if Mr. Callahan wants to address your concerns himself.
Your Honor, Ms. Harrison does not recognize that she has a major mental illness problem, but she's been examined for it. The plaintiff in this case wants her to get probation, deferred adjudication, but she wants her to stay away from her. They get into fights, and that problem should be avoided. She has the support of her mother's in the back of the courtroom. Raise your hand.
Right.
And that's where she would live. She has expressed to me that her method of handling problems is poor, bad. She wants to change it, and her own self-rehabilitative efforts at the two programs indicate that. You can trust her. I asked the court to go along with the plea agreement. May I address the court further?
Yes.
Harrison would like to speak to you, Your Honor.
Yes.
I just want to say I'm sorry for my actions. I was just trying to get my daughter back from the situation. I didn't want to be back in here. I've been taking parenting classes. I'm supposed to get my parenting class certificate tomorrow. So I make it today. I know I got a CPS class that I had to take. If you do it this week to get my daughter back, I'm just trying to right my wrongs and do better for my daughter.
All right. Probation.
Yes, Judge.
Anything to say on this matter?
I will be back to what Ms. Ferguson had to say.
She wants to get out to get her child back, and she promises to do better.
Your Honor, I would say, as the court noted before, this is not the first MTR for a violent offense. And with the 3 new cases, the probation department is recommending revocation.
All right.
It appears that she has not completed the BIPP class, her parenting class,
Oh, just 1 second.
And I do not have on here, I would have to look in the system of any UAs that she's completed. I don't see that she's paid anything toward her fees or fines as well.
All right. So, Ms. Harrison, you may want to speak to your attorney. I'm not going to follow this plea bargaining agreement. It's rare that I don't follow plea bargaining agreements, but I'm not going to follow this plea bargaining agreement. Now, I understand that probably, and I'm making an assumption, I understand that probably you entered the plea to the deferred and then entered a plea on the motion to revoke, thinking that the court would probably grant your deferred and therefore not revoke you on the other. If that was the assumption you had, if you've made a plea in the motion to revoke, I'll allow her to withdraw that plea and it can be set for a contested hearing.
We withdraw, Your Honor.
All right. So I'm going to allow them to withdraw their plea to any allegation.
This is where Judge Boyd earns every ounce of respect, calling out the lie directly to her face. She swears up and down that she completed parenting classes, yet probation's paperwork flat out proves she hasn't. That's not a misunderstanding, that's a calculated lie. And when you're already in court for violence, lying to a judge is basically self-sabotage on steroids. Boyd knows that giving her a plea deal here would be rewarding bad behavior, and the justice system doesn't work if second chances are treated like coupons. In fact, studies show that defendants who violate probation early on are far more likely to.
This right here is a huge legal red flag. Early probation violations are one of the strongest predictors judges use to decide whether someone deserved leniency or lockdown. So when Boyd shuts this down, she's not being cold. She's following the data. Question for you. If someone lies this easily to a judge, should the system really gamble on giving them another chance?
A super alcoholic.
In the motion to revoke, and we'll set the motion to revoke for a contested hearing. And then whatever you all choose to do on the new case, you're more than welcome to do it. How much time do you need, Mr. Callahan?
At the court's convenience, Your Honor.
All right. State for a contested hearing.
2 to 3 weeks, Judge.
All right, Ms. Ferguson, can you recall this back for a contested hearing? State of Texas versus Rolando Valadez. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Kelly Piddle.
And are you Mr. Rolando Valadez?
Yes.
All right. Are both parties in receipt of the TAP evaluation state?
Yes, Your Honor.
Defense?
Yes.
Any objection to the TAP evaluation state?
No, Your Honor.
Defense?
No.
All right. According to the plea bargain you entered, punishment is to be assessed at 9 years in the prison. The state is recommending community supervision. Is there anything you wish to say on behalf of your client?
No, Judge, we just ask that you follow the recommendation, and Mr. Valdez has not had any violations on his actual interlock. And once the court has ordered him to do the AA daily, he has been doing that, and he's found that to be helpful. So,
All right. All right, Mr. Valadez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Yes.
state your name for the record.
Yeah,
Rolling like this.
no problem. So the TAP
And just like that, we pivot to a completely different courtroom energy. New defendant, new risks, same underlying question. Can the court protect the public without throwing the book too fast? Because alcohol cases might look less violent on paper, but the consequences can be just as deadly.
court for alcohol use, right? So that means that you're probably a person who cannot drink alcohol at all.
Right.
Some people can take one drink, they stop, they're done. Other people, they just continue to drink. So I'm going to order, even though you've been doing the sober meetings, which I appreciate, I'm going to order the intensive outpatient treatment. Do you understand?
Yes, ma'am.
All right. So are you employed?
Yes, ma'am.
What do you do?
I work for Texas Highway and we work for highways,
Mhm.
do highway streets. Yes.
So are you all a part of cleaning streets or repairing?
We do the,
Builds them.
Yeah.
What?
He builds them.
we add more streets to it,
Oh, are you building streets or is it the freeways?
like the freeways. We're making more lanes.
He's been working on 35 for 20 years, Judge.
Oh, yeah. You know, there was somebody who told me that they have been seeing work on the freeway
Yes, ma'am.
since they were a little boy. That was Judge Carruthers. And he's like, they still working on it. So I don't think they ever finish. I don't know what that is. Why is it in other countries, people will work on a highway, like a highway gets destroyed. And then once the concrete or whatever materials they use have cured, it's like it's done. Why does it take so long here?
The weather sometimes, but the material and the process of in and out.
Mhm.
Because the streets gotta be open, so we need a lot of people directing the traffic.
Mhm.
And it's a lot of mistakes and stuff, accidents.
Oh, I don't think you should say
So
mistakes.
it's a lot of, like, little
Yeah.
minor things.
Oh, wow. Well,
Yes.
thank you very
Yeah,
much.
was there. Kenny.
Okay. Well, I hope people will slow down when they see you all working.
Yes, ma'am.
All right. Then I'm going to follow your agreement. This is what I'm going to do. I'm going to sentence you to 9 years in the prison, suspended and probated for 9 years. We'll do intensive outpatient treatment with probation. If there's an issue with that in your job, because I know your work hours are probably either early in the morning or late at night, just make sure you stay in contact with probation and let them know. If you feel like there's an issue where you're missing work or you can't miss work because they're going to fire you or something, let probation know. If you feel like they're not able to help you, you can always come back to the court or call your attorney and you can come back to the court. You understand?
Yes, ma'am.
All right. There's to be regular reporting by Zoom or in person. Ignition interlock. That's for the full term. And I just noticed that was outside the agreement, Mr. Peddle.
Right, Judge. We're asking that it be for half the term and then be evaluated by the court to see how he was doing.
All right. I'm going to put it for full term, but I've noted it on the docket sheet that can be evaluated. So after the half term of this, if there are no issues, more likely than not, I'll have it removed. All right.
Yes, ma'am.
So just come back to the court at half the term. Probation at half the term for ignition interlock. We can see how he's doing. I'm going to order full term for now, but that's open. All right. There's a $500 fine that will be probated. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors.
Yes, ma'am.
All right. So we can go off the record. So you work with highways. So, a lot of times there's a lot of accidents and it's because people who are driving while intoxicated. And usually the person who's injured, if there's an accident and somebody's driving intoxicated, it's not the intoxicated driver. It's usually their passenger or somebody else.
I've got to admit, the sentencing felt pretty balanced. The defendant came in respectful, and that matters. It shows at least some awareness of the situation, but respect doesn't erase the danger of drunk driving, and Boyd nailed it when she reminded everyone that it's rarely the drunk who pays the price. That's the harsh truth. DUI cases are tragic because the innocent usually take the hit. What Boyd is balancing here is punishment with deterrence, making sure the sentence both fits and sends a message. Legally, sentencing guidelines for DUI vary widely, but the common thread is public safety. And that's exactly what's on her mind. It's also worth noting that repeat DUI offenders face exponentially harsher penalties, so this guy is lucky this is his first. Still, driving under the influence puts every random person on the road at risk, and there's no undo button if it ends in tragedy. Respectful or not, the law can't gamble with that. So yeah, I'd call this fair, but definitely not light. Do you think Boyd struck the right balance, or was it too lenient? Let's go ahead and jump into this next hearing with a smug brat who violated her probation with even more drug use. Let's go ahead and see how this train wreck unfolds.
So you cannot drink or drive. And because you're on probation, even at your own house, because I know the holidays are coming up. I know that there's New Year's, there's Christmas. People always want to drink alcohol maybe, or drink champagne or something. Even at your own house, you are not allowed to drink alcohol while you're on probation. Do you understand?
Yes, ma'am.
All right. Good luck to you.
Thank you.
All right. Thank you. 2018 CR. All right. If you all could not talk behind the court reporter, please just move it towards the end. Court is calling 2018 CR 10107, State of Texas versus Priscilla Amaya. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Lorraine Hafer for Miss Amaya.
And are you Ms. Amaya? Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, I did.
Are you the same Priscilla Amaya who was placed on deferred adjudication in 2018 CR 10107 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram, on June 28, 2019 for a period of 3 years? Is that you?
Yes, yeah.
State?
Yes, Your Honor. Violated condition number 5 in Bexar County, Texas. The defendant Priscilla Amaya did then and there fail to report to the supervision officer as directed for the months of November, December 2021 in violation of condition number 5.
How do you plead to that? True or not true?
Violating conditions, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, Your Honor.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, there is, Your Honor.
Yes.
Yes, for adjudicate guilt, revoke the provision, and sentence the individual to 11 months in the state jail facility.
No objection, Judge. That's our agreement.
All right, Ms. Amaya, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right. So what went wrong with you?
To be honest with you, Your Honor, well, I relapsed and I didn't want to report. I thought working was good enough, but I didn't have my family intact, my kids all together. They were disappointed in me, so they stopped talking to me. But now
Sorry, can you speak up?
I have my kids back in my life and I have my first grandbaby, so I see things different. I know I do need help, and I'm willing to take that help as an outpatient when I get out of Bexar County Jail.
Here's the thing. If you want to remain on deferred adjudication, I will let you remain on deferred adjudication, but you're going into inpatient treatment or either you're going to felony drug court. Now, you say, oh, I want to do my time. I will get out and I will take care of things and I will be clean and sober. 9 times out of 10, that's not going to happen. You know why? Because you are looking at 2 years in the state jail facility and you couldn't do it. And you are a person who should not be around your grandchildren or your children because you don't have control of your addictions. You're using opiates. You need help. So if you want, here are your 2 choices. State and defense, they came up with their agreement. Here's your choice. 1, you can be referred to felony drug court. If felony drug court accepts you, great. If they don't, you go into inpatient treatment. Or you can go to the state jail facility for 18 months. Either way, your life, the time is going to pass. Either it's going to pass with you bettering yourself by taking care of your drug addictions, or either it's going to pass with you marking days off the calendar, just doing your time at the state jail facility. So which do you prefer? 18 months at the state jail facility, or perhaps getting treatment for your drug addiction, being the type of grandmother that your grandchildren can be proud of and that your children can be proud of? It's completely up to you.
May we have a minute, Your Honor?
Yes. Maya, are you still discussing?
We're ready, Your Honor.
All right. So we're back on the record in 2018 CR 10107, State of Texas versus Priscilla Amaya. So Ms. Amaya, have you had a chance to discuss things with your attorney?
Yes, Your Honor.
So which do you prefer?
Your Honor, we're going to take the state jail time, but we are requesting that the court, if the court has the ability.
This is one of the most brutally honest moments you'll ever hear from a judge. No sugarcoating, no legal fluff, just a fork in the road, treatment or time. And here's the uncomfortable truth. Judges see this speech fail more often than it works. So what would you choose if you were standing there? Bet on yourself or take the sentence and hope rock bottom finally sticks?
Give you credit for any time served, and the court will recommend the therapeutic community. Therapeutic community will not increase the amount of time that you're in custody, but I do not have the authority to have them place you in there. The only thing I can do is request and recommend it, but you're also going to have to ask for it. You understand?
Yes, sir.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement,
Well, not
Well,
actually.
she's waived her right to appeal.
Okay, that's right.
Yes.
You're right.
Thank you. And you've waived your right to appeal. You do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
I'm 40.
All right, you're 40. You still have a lot of your life in front of you, and you need to make a decision. And I know staying clean and sober is hard. And this is from somebody who's never done drugs, but I understand it's hard based upon my experience in different treatment courts and based upon the fact that I'm having a struggle giving up ice cream. And ice cream is not even as addicting as the drugs that you're taking. But if you don't stop, 1 or 2 things are going to happen. Either you're going to continue going in and out of the prison, or either you may end up with a bad batch and you may end up overdosing. And I don't think you want your children or your grandchildren to read about you in the news where it's bodies found on whatever street it is. And then they finally identify it and it's you. You understand? But you're going to have to work for it. And when you get out, there are plenty of places that have free treatment for you. Okay. All right. Good luck to you.
Thank you.
You're welcome.
Judge Boyd wrapped up these cases with a mix of patience and firmness, and overall, I think she handled them pretty well. Personally, I might have leaned a little harsher on the probation violating defendant because her so-called new perspective rings a bit hollow. She says her grandkid gave her a reason to change, but if raising her own kids didn't spark that, why should we suddenly believe it now? It's a fair story to tell the judge, but stories don't equal proof. What we saw today highlights a bigger issue. Courts constantly have to gamble between giving someone one more chance or protecting the public from another repeat offense, and legally, probation isn't a freebie, it's a contract. Break it, and the system is supposed to step in harder the next time. I think Boyd walked that line cautiously, maybe even more generously than I would have. But what do you think? Did she give too much benefit of the doubt, or was it the right move to test her commitment to change? Drop your thoughts in the comments. I want to hear your take.